though she signed a non-binding volunteer agreement. 1 year later, she maintains, she was required to cease to act in circumstances amounting to discrimination against her on the ground of her disability. The substance of this claim has never been adjudicated. The Employment Tribunal, the Employment Appeal Tribunal, and the Court of Appeal have held that as a volunteer, she was outside the scope of the protections against discrimination on grounds of disability afforded at the relevant time by the Disability Discrimination Act 1995 and by European Directive 2078/EC, to which that act gives effect. If that is so, the Employment Tribunal had no jurisdiction. On its face, the 1995 Act did not protect the appellant against discrimination on grounds of disability. This is because the Act only extended to persons employed or working under a contract. The appellant had no contract, but she submits that a different analysis is required when regard is had to the directive. The directive applies by Article 3(1)(a) in relation to conditions for access to employment, to self-employment, or to occupation. The appellant submits that as a volunteer, she had an occupation within the meaning of Article 3(1)(a), and that the requirement that she leave the Citizens Advice Bureau amounted to a condition affecting her access to that occupation. The Supreme Court does not accept this interpretation of the directive. It concludes that the phrase conditions for access to occupation contemplates access to a profession or other sector of the work market. Dismissal is dealt with not by Article 3(1)(a), but by a different subparagraph, Article 3(1)(c). Article 3(1)(c) relates simply to employment and working conditions, including dismissal and pay, and makes no reference to occupation. Various other considerations also support this conclusion. Other language versions of the directive refer to occupation as professional activity, and the German version expressly limits protection to remunerative activity. No reference was made to voluntary activity in the Commission's original proposal at all, or in its impact assessment. And a proposed amendment by the European Parliament to introduce the words unpaid or voluntary work into Article 3(1)(a) was the one amendment not accepted by the Council when it issued the directive. The Commission, in its periodic reviews, has never suggested that the 1995 Act's express limitation to contractual situations involved a failure properly to implement the directive. The Court concludes that Article 3(1)(a) of the directive does not cover volunteers, that there is no scope for reasonable doubt about its interpretation in this respect, and no basis, therefore, for a reference to the Court of Justice of the European Union. It is unnecessary in these circumstances to address the question whether, if a different conclusion had been reached in relation to the directive, this could have given the appellant any domestic remedy by application of either of the principles recognized in the Court of Justice in the cases of Marleasing and Mangold. In the upshot, this appeal will be dismissed.